Good afternoon, everybody. Welcome. My name is Jocelyn Kennedy. I'm the Executive Director of the Harvard Law School Library. Welcome to our book talk. Before we begin, I just have a couple of housekeeping notes. We are being recorded. This will be shown on our YouTube channel, the Law School's YouTube channel, early next week. Any questions you ask will also be recorded, so you're on notice that you could be famous on the YouTubes. It's my pleasure also to thank the Dean's Office for helping to sponsor the library book talks. And this particular book talk is also co-sponsored by the South Asia Institute here at Harvard University, as well as the Law School's South Asian Law Students Association. So I want to thank them for their co-sponsorship as well. And then to get us started, it's my pleasure to introduce Vasujit Ram, who is the editor of our book, and he's going to introduce our panel. Thank you so much.
Thank you, Jocelyn, for the introduction. I'd like to thank June Casey and Jane Bester for helping us organizing this talk. On behalf of Vikram, my co-editor, who is here with us today, and myself, thank you all so much for coming. We have a terrific panel of scholars today to discuss the book. I will introduce them in the order in which they will speak. Professor Mark Tushnet is the William Nelson Cromwell Professor of Law and an expert on constitutional law. Professor Mitra Sharafi is visiting all the way from the University of Wisconsin Law School, where she is an associate professor of law and a legal historian of South Asia. Professor Sugata Bose is the Gardiner Professor of Oceanic History and Affairs in the History Department of Howard University. He is also a South Asia specialist and a member of Parliament in India. I believe the comments will be informed by research in their respective fields of expertise. I will provide a very brief introduction about the book before I hand over the mic to the panelists to share their thoughts. The author of the book is Professor George H. Gadbois Jr., who was an emeritus professor at the University of Kentucky and a scholar who studied the Indian Supreme Court for several decades. Incidentally, he was born and raised here in Boston, Quincy, I believe, in Massachusetts. This book was originally written as a PhD thesis in Duke way back in 1965. A couple of years ago, Vikram and I, we persuaded him to publish the work. He was a perfectionist, and he accepted our suggestion after we prodded him several times, and only after 3 renowned scholars certified that it is fit to be published. He asked us to join him in editing the manuscript, and as his health was deteriorating with a terminal illness, he passed away in February 2017, and we worked on publishing the book with the support of his family. I would like to especially acknowledge Judy, his wife, who is also present here. She We wrote a long introduction commenting not only on the contents of the book, but also providing an intellectual biography of Gadbois and his scholarship. So this book provides an institutional history of the Indian Supreme Court. The body is a powerful institution on paper. It appoints its own judges. It can strike down constitutional amendments, and it can even take up cases without a petitioner. So how did we get here? It's a long story, but this book offers a glimpse into the origins of that story. The book begins with early efforts in colonial India around 1921 to establish its own final court of appeals. Some leaders wanted to limit the authority of the Judicial Committee of the Privy Council, the colonial body that sat in London and acted as a court of last resort for the British Empire. However, the prestige and influence of the Privy Council and the low priority for judicial autonomy as opposed to political autonomy among Indian leaders are factors that slowed the establishment of such an institution. In a limited sense, the demand for an indigenous final court was acceded to in 1937, though through the Government of India Act 1935, the Federal Court of India, the predecessor to the Indian Supreme Court, was established. It was, however, a body with limited jurisdiction that was still subject to review by the Privy Council. Gadbois studies the evolution and functioning of that body which operated until 1950. This colonial institution which, operating for most part of 3 judges, 1 Englishman, 1 Hindu, and 1 Muslim, compiled a stellar record on civil liberties even during wartime and left behind a great legacy of impartiality and independence. The jurisdiction of the Colonial Privy Council formally ended only when the federal court's successor, the Supreme Court of India, was created under the Indian Constitution of 1950. The Supreme Court is vested with extraordinarily wide jurisdiction and the power of judicial review. This book surveys the Constituent Assembly debates and the Supreme Court's record until the death of Prime Minister Nehru in 1964. The book closes with an assessment of the role the court played in the then nascent democracy. With this brief introduction, I would like to turn the mic over to Professor Tushnet. Thank you.
I want to thank the various sponsors of this event, but also the editors of the book for bringing it to fruition. It's an important contribution to understanding the early years of Indian democracy and the Indian Supreme Court in particular. I'm going to talk briefly about some of the early decisions of the Indian Supreme Court. And the basic argument is, or the starting point, is that from really the very beginning, the court was what we would characterize as an activist court, striking down significant legislative initiatives by invoking the Constitution. So in a series of cases described in the book, various state governments adopted land reform programs that were aimed at redistributing land from large landholders to poor people, and the Supreme Court invalidated a fair number of them on the ground, roughly speaking, that they didn't provide adequate compensation to the prior landholders. In addition, in an important early case, the court invalidated what we would now characterize as an affirmative action program aimed at improving the condition of lower caste individuals. Now, what's interesting about this is this is quite active. These are programs that are important to the governments that are sponsoring them. The court exercised no, I think it's fair to say, expressed no particular concern about its exercise of power. It was authorized to do so and to act, and it did. But for me, the interesting part of the story is what happens next, which is that in each of these instances, the Parliament amends the Constitution to overturn what the Supreme Court has done. Now, that's possible because, first of all, the amendment rule is in the Indian Constitution is, relatively speaking, a quite easy amendment rule. It takes only parliamentary action, and the required majority is not enormous. But the second point is that the amendment rule could be deployed because this was a time when the Congress Party was dominant and had an amendment, a majority adequate to deploy the amendment rule. So you have this interesting phenomenon, I think, of an activist court striking down important legislation on the basis of the Constitution, and call it a legislative response, a response on the constitutional level by the legislature to reject what the court has done. Now, one way to understand this is to say that the court could be activist precisely because it was operating in a system with an easy amendment rule and a dominant party. I don't want to attribute motivation to it, but you can imagine judges saying to themselves, well, we should do what we think needs to be done, and if there's disagreement with it, then the result is not going to stick, but we don't care about that. We're interpreting the Constitution that we have. If they amend the Constitution, we'll interpret that, the amended Constitution. So the story I would want to tell, this is a story up until the erosion of the Congress Party dominance, which is after the end of the period in this book. And so to continue the story, the way I would tell it is that you have a court that understands its role as call it detached analysis of the Constitution, which in the period of Congress Party dominance has relatively low consequences in terms of displacing democratic decision-making. Because, again, they can do it. If the Congress agrees, then it's fine. And if the Congress disagrees, the Congress Party disagrees, then the result will be overturned. After the now, there's a story that's conventionally told, which is that Congress Party dominance disappears, the emergency occurs, the court concurs with the emergency and becomes, to some degree, discredited by that occurrence. And then when the emergency ends, and in some ways easing the way to the emergency, to the end of the emergency, the court tries to regain its credibility by actively intervening again. And there's something to that story, but I think an important component of the revitalization of the Indian Supreme Court is precisely the disintegration of Congress Party dominance after the emergency. Because the story I would tell is, well, they got used to and developed a role conception of themselves as, again, to shorthand it, activist judges. That's who they were. After the disintegration of the Congress Party dominance, you have a consequential court. Before, they could do what they wanted, and if Congress disagreed, it'd be overturned. Now, if they do what they want, now in the post-emergency period, if they do what they want, it's going to stick. Now, there are problems with government capacity, whether they can actually pull something off, but it's not that there's going to be pushback from a unified government against them. And so they developed this further jurisprudence of activism, quite activist. There's articles that call it the most activist court in the world and things like that. And they're able to do that because of the existence of a multi-party, non-dominant system. What's interesting now is that we may be seeing the reconstruction of a different dominant party system in India. And one indication of that is the adoption of a constitutional amendment purporting to, attempting to change the method by which the members of the Indian Supreme Court are selected. But one of the things that happened in the intervening period is that the court developed this jurisprudence, the basic structure doctrine, that allowed them to strike down constitutional amendments as themselves unconstitutional, and that's what they did with respect to the change in the method of selecting the Supreme Court justices. So what they developed, another way of putting this is, what they developed is something they didn't have in the first period, which was a technique of responding to the responses by a dominant party to their jurisprudence. Now, if the dominant party persists and this basic structure kind of mechanism gets deployed increasingly, I think there'll be interesting developments. We don't know what they would be, of course. but the combination of a dominant party, an easy amendment rule, a dominant party, and the basic structure doctrine transforms the nature of the court's activism from what it was in the early period to something else, the contours of which we have not yet seen. Okay, thank you.
Thank you, Professor Tushnet. Professor Sharafi.
Great, thank you. Well, I'm coming at this obliquely from the side in a way. First of all, because I'm a scholar of the colonial period of India's legal history. And so where I end, actually, George Gadbois's book, we have an overlap for a couple of years on the federal court, but mostly he's looking at the independent period. And secondly, because there are a number of courts in this story, and I've worked on and with the archives of a couple of them, but they're not the big courts that the book is focused on. That is the federal court and the Indian Supreme Court. I've worked in the Bombay High Court and with the Judicial Committee of the Privy Council. So I'm kind of coming at this from the side, like I said, in a couple of ways. The first question I'd like to ask is, what does George Gadbois's book and dissertation have to offer us 53 years after it was completed? There's an unfortunate tendency, I think, with a lot of scholars to stop reading scholarship that is more than about 30 years old. And there's no real reason for it except volume, I guess, but it's not really a good reason. Occasionally, I do dip back into work on Indian legal studies from the 1960s and 70s, and I'm thinking of work by people like Mark Galanter, Upendra Bakshi, Rajiv Dhawan, Granville Austin, and George Gadbois. And when I do that, I'm often reminded of the fact that we should not reinvent the wheel. We should just read some of the older classics in our field. I learned a couple of things from reading this book in answer to questions that I've had for a long time. One was, how is it that Indian Supreme Court judges must retire at the age of 65? It has all kinds of consequences, very, very high kind of turnover in judges because of this rule. So how did the rule come to be? This book answers that question. Another question I'd had for a long time was, where does this attitude come from in India that criminal appeals should be kept largely out of the upper courts? Again, his book addresses the history of that discussion. So I got a lot out of reading this book. I think when we look at very new scholarship that's coming out, it will be wonderful to read George Gadbois's dissertation alongside work by scholars like Rohit Day, who has written about the federal court and has got a very exciting book coming out on the Indian Supreme Court, and on the new book by Arun Tiruvengadam on the Indian Constitution. A second thing that Gadbois's book offers has to do with a tradition of scholarship coming out of the U.S., and particularly, I think, coming out of U.S. legal academia, and that is there's a long history of comparative studies looking at Indian and U.S. law and courts by scholars based in the U.S., and there's been a tendency sometimes to end up asking the question, how is it that India ended up lacking feature X, which we have in the US? And when I started reading the book, I wondered if that was going to be an issue, and I wondered if that was going to be the approach, but I was very happy to see that it's not. George Gadbois looks at Indian courts and Indian law on their own terms. There is a thread of kind of comparative elements, US-India, in the book, but it is embedded in the original primary sources that he's using. So he has a big discussion about why there is no due process clause in the Indian Constitution. And you could think, well, why would there be? Why should we assume a kind of universal American baseline? But the fact is that there was initially a due process clause in an early draft of the Indian Constitution, and then it got removed and replaced with something else. So he is addressing debates of the era, comparisons made of the era between India and the US, rather than imposing the American comparison himself from the outside. So I was very happy to see that approach being taken. I will also say the conclusion of the book is absolutely superb. It is probably one of the best conclusions I have ever read in a book. Writing a good conclusion is a really hard thing because you want to summarize, you have to summarize, but you also need to do something a little bit more. There needs to be some interesting twist or extension or added question. It can't be too new because then it should really be a separate article or even book itself. This conclusion, if you're looking for a great model of a book conclusion, I highly recommend that you read this, because what he does is he says, what are the 10 most important moments if we move through the whole period that the book covers? And so it's a summary, but it's also put in a slightly different way, and I thought highly productive and a great model. Finally, I'll just say that George Gadbois's book has now, as much as he was writing it as scholarship and what we historians would call a secondary source, his book has now become a kind of primary source because it reflects upon the Indian Supreme Court in the 1960s when he was writing. And so a very big thank you to Vikram Raghavan and to Vasujit Ram for making this book happen. I know it was a big project, and it took a lot of time and energy, but it was worth it. And thank you for your wonderful introduction, and thank you to George Gadbois's family also for your help and cooperation. The one thing that I noticed here when asking myself the question, well, how have dissertations changed between 1965 and today? The one thing I will say is that I think if this dissertation were written today, there would be more of an emphasis on archival research, so research using unpublished sources, because the sources that are used here are all published. And so this is true, I think, certainly if you were a historian doing this work, but even as a political scientist doing qualitative historical work, or a historical sociologist. Today, I think there would be more of a focus on archival research as far as methodology is concerned. Let me shift gear now and think a bit about how to situate this work historically. And because of my own focus on the colonial period, I'm really going to situate it across the colonial and post-colonial period of Indian history. So first, a little bit about courts, new courts, and founding institutional moments. The two courts that are at the forefront of this book that get the spotlight are the federal court, created in 1937 and ending its life in 1950, and then the Indian Supreme Court that began its life in 1950. But there are two other courts or court systems that are kind of in the part of the portrait, but a little bit more in the backdrop. The first is the Judicial Committee of the Privy Council, which was the final court of appeal for the British Empire. I will say on this, I've done work on the Privy Council and with their archive. It's still a functioning court today on Downing Street. And I will say I was a little bit surprised by the book's very kind of positive, its account of very positive associations with the Privy Council, put it that way, because in my own research I found a lot of criticism of the Privy Council. And the criticism was essentially that this court, the judges were dilettantes. This was a court that decided appeals coming from all across the British Empire. So they're dabbling in all of the different religious personal law systems from South Asia and elsewhere. Also not just common law traditions, but Roman law traditions coming from places like South Africa and Quebec. And so there was criticism, not only from India, but from other parts of the empire, a lot of criticism of the judges and the fact that they had not been trained in these legal traditions, and yet here they were handing out judgments in these areas. So I guess I do differ a little bit with George Gadbois in that one respect. The final court that is part of the picture here is a whole system, and that is the system of the high courts of India. Those were created in 1861, and I think that our field of Indian legal history needs more work done on that founding moment. I have an SJD student named Cynthia Farid who is in part working on this, but I think there's space for other scholars as well. It was an incredibly important new set of courts, and it signaled a real change in legal culture and the legal profession specifically, because the rule change that accompanied these new courts allowed the legal profession in British India to become Indianized over the next few decades. That would also have huge consequences, not just for the legal system, but for Indian political history as well, because many of those London-trained barristers from India ended up leading the independence, the nationalist movement. So I think we need to know more about the high courts, 1861 and onwards. Okay, the big theme that I wanted to think about historically is the colonial continuities question. Now, we might hear about this in the news regularly now because of the debate over LGBTQ rights in India. And any day now, there's going to be a new Supreme Court decision in this area, and that's going to be it's going to be very important. But one critique that you see of the Indian Penal Code, Section 377, which is the unnatural offenses provision, including an anti-sodomy provision, one critique that you see regularly is that this is a colonial era law. And I've always found that critique a little bit odd because, as George Gadbois notes in his book, most of large swaths of Indian law are colonial era law, both legislation and case law, and a lot about how the legal profession runs are essentially the same as they were, I would argue, in the colonial period. So I've always found that a curious line of attack. What changed across independence? Well, obviously the Constitution and the creation of the Indian Supreme Court. What did not change? Well, lots about legal culture and the legal profession. I want to focus on two things. First of all, I'll just say that a lot of employment priorities remained the same, I think, across independence. One of my favorite parts of the book is Chapter 3, which is all about the kind of the mechanics and inner workings of the judiciary, so judicial appointments, judicial pensions. These things are incredibly important. They occupy a huge amount of people's mental energy, I think, and they explain a lot about patterns that you observe. They're often quite hard to get at if you're not inside the system yourself, and they're often very dry and boring to write about. But this chapter is actually extremely interesting. When I'm working in the Colonial archives, I'm often struck by how it seems like 50% of the archive is about pensions, appointments, promotions, and leave. And I've often thought about doing a project on employment law in the empire because it's so important. So this chapter I thought was really marvelous, and that set of priorities has kind of continued across the colonial, post-colonial divide. The thing I really want to talk about, though, is the rule of law. So I want to situate the role of the rule of law in colonial and then post-colonial Indian history. What the book offers us is a portrait of the continual struggles between the courts, upholding rule of law values and constitutionalism on the one hand, and the struggle with the government, attempting to rule with unfettered power. I would argue that this is a story of continuity more than change as we move from the colonial to the post-colonial period. Now, the aims of the two different governments, of course, changed radically. The colonial government was all about the continuation of colonial rule, and colonial rule was all about the extraction of labor, profits, and commodities from the colony for the benefit of metropolitan elites and the metropole. The post-colonial state is all about Nehruvian socioeconomic reform projects, at least up to the point that the book ends. So I would argue that while the aims of the governments differ, this struggle between rule of law values and the courts and governments is there both before and after independence. Now, there's a problem in the field of Indian legal studies, and that is that there are two subfields that are speaking past each other. On the one hand, we have historians of colonial law who see the rule of law as inseparable from colonial rule, so they vilify it. They see the rule of law as the handmaiden or servant of colonialism. And then on the other hand, you have scholars of the post-colonial period who see the rule of law as exerting limits on state power. So they take more of the kind of classic lawyer's approach, you could say. And on balance, they are positive about the rule of law as a set of values. The colonial historians, if asked to explain their position, see the rule of law as inescapably colonial because they point to, first of all, the fact that the rule of law was used as a pillar of the British civilizing mission. So that is that the rule of law agenda was used as a justification for what the British were doing in India at all. Historians of the colonial period also point to all of the racial injustices and inequalities carried out through the application of colonial law. And here I think they make a mistake in the sense that they mistake rule by law, the practical application of law in India, with the rule of law as a set of values, as a set of ideas. I would argue, and I make this argument in a forthcoming article, that the rule of law, despite all of the contradictory practice in colonial India, the rule of law retained immense rhetorical power as an ideal. Rule of law values were deployed in conflicts within the colonial state. We have the story of the federal court in the very end of colonial rule, upholding the rule of law in the face of wartime government legislation. We also have before that groups like the Punjab School of Public Administration, which essentially wanted to rule India without law. We have many accounts of European members of the Indian civil service in the colonial period who regarded lawyers, judges, and the courts as their natural enemies, as obstructions to colonial rule. Plus, the rule of law as a set of ideals was used by the early nationalists, by the early Congress movement, especially a group known as the Constitutionalists, people like Dadabhai Naoroji, Firozshah Mehta, and Dinsha Vacha, to point to the gap between British values and British practice. Un-British rule is what they called it. So my view to the question, what was the relationship between the rule of law and colonial rule, is that they were in a symbiotic relationship for much of British India's history. They were intertwined in a relationship of mutual dependence that brought significant benefits to each, but they were different projects. Sometimes they were at odds, and eventually one, the rule of law, would help destroy the other, colonial rule. Why did the British then celebrate rule of law values so much? I would say because it was packaged and ready to ship in imperial metropolitan thought. But the British underestimated the concept's autonomy and its potential to erode the foundations of British rule. If we look at it this way, the rule of law was not inescapably colonial, and thus the rule of law and constitutionalism in independent India were not mere post-colonial hangovers or reflections of false consciousness. So if we put this book, George Gadbois's book, together with the longer context of modern Indian history, we get a long and distinctive history in India of rule of law values attempting, at least, to act as a counterforce to unfettered government power. And we see that both in the colonial and in the post-colonial periods.
Thank you, Professor Sharafi. Professor Bose, thank you. Thank you very much. First of all, I'd like to congratulate Vikram Raghavan and Vasujit Ram for editing this really classic work by George Gadbois. This is a work that needed to be brought before the public eye. And even though, as Professor Sharafi was suggesting, that perhaps these days we would expect PhD students to do more primary research in their archives, this is a work which I would present to my own PhD students as a model in terms of clarity of argument and the lucidity of its prose. This is a truly important work, and it ought to stand side by side with the much celebrated work by Granville Austin on the Indian Constitution. And also, of course, it's important to place this work in the context in which it was written. This is a mid-1960s Duke PhD dissertation in the discipline of political science. I think we have to note that Gadbois's research supervisor was Ralph Brabanti, and who had pioneered a particular kind of institutional history. Brabanti, of course, worked on the bureaucracy, the civilian bureaucracy as an institution, and here was Gadbois as a student working on the federal court and the Supreme Court of India. Now, these days, we have a new generation of legal historians who are, looking at ideas and institutions within the same framework. One of them has been mentioned already, whose work I truly admire, Rohit De, whose book on the Supreme Court will come out shortly. Another is a former Harvard PhD student of mine, Julia Stephens, whose book on colonial and Islamic law will also appear from Cambridge University Press later today. So there are, new approaches that are being fashioned, but old classics do stand the test of time and need to be read by contemporary students and scholars. In the brief time that I have, I'll make a few comments as a historian, of the period that this book covers, which is the early 1920s to about the early 1960s. And I'll add a few comments based on my unusual experience as a historian among the politicians, since I have, and I had gained this rather unique anthropological experience of, looking at the maelstroms of Indian democratic politics from within over the last few years as a member of parliament. Now, as a historian, I mean, this is a work on the federal court and the Supreme Court, and I think Professor Sharafi is absolutely right in saying that we also have to keep within our view two other courts, the Judicial Committee of the Privy Council in this period and the High Courts. Now, it's very interesting to see why Muhammad Ali Jinnah supported Dr. Gore's resolution, wanting to set up a federal court. And here is an example of the criticism of the Privy Council that Professor Sharafi was alluding to. I have no hesitation in saying that the Privy Council have on several occasions absolutely murdered Hindu law and slaughtered Mohammedan law. So that's why, Jinnah, along with eventually Tej Bahadur Sapru and one or two other members of the central legislature, Motilal Nehru as well, came around to supporting the idea of a federal court that would be based in India. Now, it's worth emphasizing that the federal court was created as a result of the Government of India Act of 1935. And this Government of India Act of 1935 had two parts. There was a provincial part and there was a federal part. And we really have to recognize that this 1935 Act was designed by the British to find ways, constitutional provisions of staying on in India rather than getting out of India. And so the provincial part tried to direct Indian political attention to the provincial arenas. And there were elections in 1937 to 11 provincial legislatures. And the Indian National Congress at that point decided to work the provincial part for what it was worth, even though they had some reservations. But so far as the federal part was concerned, by and large, across the political spectrum, Congress leaders like Jawaharlal Nehru and Subhash Chandra Bose, Muslim League leaders like Muhammad Ali Jinnah, were very critical of the federal part of the Government of India Act, because what it provided for was a federation in the future between the princely states, some 565 of them, and the 11 British Indian provinces. And what Indian nationalists felt, what this federal part was bringing in the undemocratic princes or their representatives in order to counterbalance the democratically elected representatives of British India. The rules were designed in such a way that no nationalist party could hope to have a majority in this future federal legislative assembly. That was the legislative side of the idea of federation. And this federation was for the future, that it would come into being once at least half of these hundreds of princely states had negotiated their way into the federation on their terms. So this was something for the distant future, so far as the federal legislature was concerned. But fortunately, one part of that federal aspect of this legislation got implemented fairly quickly when the federal court got established in 1937. Now, I think that overall, Gadbois's book provides us a wonderful assessment of the accomplishments and the failures of the federal court. I have some quibbles because it's true that the federal court between 1942 and 1944, led by Maurice Guire, but assisted by a Hindu and a Muslim judge, handed down quite extraordinary opinions defending civil liberties. This was in the aftermath of the passage of the Quit India movement by Mahatma Gandhi and during wartime. But we also have to note that these, very, far-sighted opinions delivered in theory did not have that much of practical import. Even in the case of Niharendu Datta Mazumdar, he won the case so far as the federal court was concerned, but he was imprisoned the very same day on sort of another charge. And I say this, partly, because, there were so many other things going on. My father, for example, who was a medical student taking part in the freedom struggle, he was just imprisoned without trial, in solitary confinement in an underground cell of the Red Fort and of the Lahore Fort, and finally Lalpur jail. And so there were huge numbers of imprisonments without trial. There were many secret trials, and executions were carried out after secret trials held in Delhi, Calcutta, Madras, and so on in that period. And of course, if one thinks about trials in terms of the larger history of that period, it was a court-martial in the Red Fort in December of 1945, which had a much bigger impact on Indian history and the post-colonial transition than whatever the federal court might have tried to do. And their intentions were good, but we have to understand that the impact of these decisions was, in fact, quite limited. This book is, the best study that I have read so far. With there are new works coming out now of the early history of the Supreme Court, and again, of course, we know that in the Gopalan case, which was a very early case, civil liberties were not defended by the first Supreme Court, but at least what we got in that early period, which has been studied, is that the basic structure of the Constitution cannot be altered through a constitutional amendment, and this counter-majoritarian role of the Supreme Court has acquired even greater salience today. This book has a really thorough and detailed discussion of the process of judicial appointments. And of course, you should all read Gadbois's other book as well, his biographies of 93 judges of the Supreme Court that had been published before. But I just wanted to say, based on my experience as a parliamentarian, that, in this day and age, we should not be simply seeing some of the challenges that we face in India as striking the right balance between the executive, legislature, and the judiciary. I say this because, there is the immediate instinct on the part of parliamentarians to uphold the sovereignty of Parliament. But in fact, a couple of years ago, a judicial appointments bill was brought before Parliament. Notice hadn't been given, not even the 2-day notice that is usually required. It was introduced, debated on the same day, and passed by a voice vote. And I had great difficulty in even explaining to my colleagues in the opposition, and we have been opposing this Hindu majoritarian government on many counts, but I had great difficulty in trying to explain to them that we should try to block its introduction, that we ought to really debate this, because this is not a question of the legislature versus the judiciary. This particular bill, I failed to explain to my colleagues, is actually giving enormous power to the executive in making judicial appointments. Of course, the Supreme Court questioned this passage of the bill in the same day and so forth. So that is a separate story. So I really do think that today, Professor Tushnet talked about the period of the emergency. In those days, we used to hear this phrase, a committed judiciary. Indira Gandhi wanted a committed judiciary, which would support radical social and economic reforms. But now the situation is, in fact, much more fraught with a Hindu majoritarian government in power. And the opposition in Parliament, in some ways, needs to rely to a very great extent on the counter-majoritarian role or the potential counter-majoritarian role that can be played by the Supreme Court. There are many important issues that are being discussed now before the Supreme Court. One is, of course, Article 377. Another is the issue of privacy, the Aadhaar card, the biometric identification that is sought to be required by the government of everyone. And at least for the moment, the Supreme Court has issued something of a stay on having to link this biometric identification with bank accounts and with mobile phones. The Supreme Court has so far said that at least until it hands down its final judgment, it should be only used for the purposes of delivering, social welfare. But, Parliament alone, opposition on its own in the legislature is fighting a very uphill battle today against majoritarian sort of and increasingly authoritarian government. And in this context, the Supreme Court has a role to play. Of course, we have now these difficulties of splits within the Supreme Court of a kind that we hadn't seen before. There were 4 very senior judges who had a press conference in the open criticizing the Chief Justice of the Supreme Court, who is widely seen to be rather too close to the government of the day for assigning cases in an arbitrary manner. And all this arose, because of a case involving the president of the ruling party. What kind of bench should it go to? So there are internal splits of a kind that we haven't seen before that have emerged within the Supreme Court, which there weren't in Gadbois's time, or the time that Gadbois is writing about, even though there were contested decisions, 5-4 decisions, but not this kind of conflict. Yet, overall, I think the Supreme Court today really has a more important and significant counter-majoritarian role to play than it has ever had in the 70 years since Indian independence. Thank you.
Thank you all. Thank you so much for your wonderful comments. I think a unifying theme was the importance of studying constitutional history to understand where we are today. And I'm glad we're here discussing this subject. I just want to make some quick points to have a conversation. Professor Doctrine, you made some very pertinent points about the court being an activist court without effect in the early years. And I think that captures the thesis pretty well. But I do have my doubts about whether that state has changed. Chintan Chandrachud, as you may know, has written a new book called Balanced Constitutionalism. And he, through a thorough empirical study in his book, he confirms the view that legislative and political responses to judicial review in India is easy, being even swifter than in the United Kingdom. I also wonder if the Supreme Court can be labeled an activist one today. Major anti-terror laws were upheld in the late 90s and early 2000s. In the early 80s, when court is usually seen to be at its most activist stage, Professor Bakshi called it juristic activism, which means that the court would recognize broad constitutional rights, but not apply that right to instant facts of the case. So in Olga Delis, which is a celebrated and landmark case, the Supreme Court recognized the right to livelihood, but a statute in that very same case providing the possibility of eviction without notice was upheld. In recent years, scholars like Gautam Bhatia have suggested that the court has evaded its responsibility to adjudicate on important matters. And I think, Professor Bose, you mentioned the other case, the world's biggest biometric ID program. The legality of that case has been pending before the court for several years now. And merely because the court has not adjudicated on that case, it's basically fait accompli. Most people already have their Aadhaar cards and other numbers. And even in the case of the power to strike down constitutional amendments, an enormous power undoubtedly, it has been used only to protect its own institution, the powers of judicial review, judicial appointments, expansion of the powers of tribunals. It's basically intra-institutional conflicts. That is a situation and context in which the power is used. So I wonder, in what context and under what conditions the court can truly be activist and acts as bulwarks against government power. And Professor Sharafi, you made some very pertinent points as well, and I just want to quickly flag a couple of things. As to the study of the high courts, which is very important, Abhinav Chandrachud has a recent book called The Indian Independent Colonial Judiciary. It's not in the origins of the Bombay High Court, but rather studies how the Bombay High Court was decolonized even before independence, and it explains how the transition from a colonial body to a post-colonial one was so smooth. And your point about the criticism of the Privy Council was quite fascinating, because the distance of the Privy Council is obviously problematic, but for many it had a positive spin. The distance gave it an aura of neutrality. I don't necessarily agree with that view, but I think at that point that was something that many leaders thought was useful to keep in mind. And as for your points on colonial continuity, again, I agree with most of your points, and I'd like to flag one other interesting point, that is the idea of protest. So in colonial periods, obviously, several laws were seen as illegitimate or unjust, and protest was seen as a way to push back against those laws. And during the Constituent Assembly debates, I think there was an extensive discussion about protests, and the leaders seemed to say that now we have a legitimate government, now we have a constitutional government, and therefore protests can't be a way to push back against these laws. So I think that is one interesting point that ties in with your discussion about the rule of law. And Professor Bose, your points on civil liberties, the decisions during wartime having no practical effect, I completely agree. Legislation and ordinances were passed the very same day or the next day that basically nullified all these decisions. And I think this is also one thing to keep in mind when we have conversations about the impacts, social impacts courts have. There's books in a completely different context, for instance, called Hollow Hope by Professor Gerald Rosenberg, about how courts can have social impacts. I think we can have a similar discussion about the impact of courts on, in civil liberty cases. But I do think it may have had some symbolic effect, and we do know that the decisions of the court and this aura of independence and impartiality carried on, and in the Constituent Assembly it was seen as a mark for the Supreme Court to uphold. And with respect to the counter-majority role for the Supreme Court, I do agree this is a critical period in which the court has a big role to play. But in light of the earlier points I made about judicial evasion and the fact that the courts have been historically reluctant, I wonder if we'll see that in the forthcoming days. So with that, if you have any comments, we can open the floor for questions.
Hi, my name is Yasir Latif Hamdani. I'm an advocate of the high courts in Pakistan. So, a jurisdiction which actually emanates or comes out of the Indian jurisdiction. My question, first of all, is just a short comment. I was very happy to hear that, at least Mr. Jinnah is being acknowledged for the contributions that he made to Indian legislative history. Also, not just the Supreme Court, but the Dehradun Academy was also one of his brainchilds. But that said, the question that I have for Professor Sharafi, I think is, I read somewhere that Felix Frankfurter was the person, the judge here, the justice, Supreme Court justice in the US, had advised B.N. Rao at the outset that don't include a due process clause or a fair trial clause, which interestingly, Pakistan in 18th Amendment in 2010 did include, and that's a very interesting jurisprudence that is emanating out of it. But I was just wondering if that is correct. And secondly, the bigger question that I have is about this counter-majoritarian difficulty, which is an issue because the basic structure doctrine, which I think it works very well in India, because you've got at the head of it secularism and sort of democratic values, but when the same basic structure sort of issue is raised in our side of the subcontinent, it becomes problematic for people like me, because we are obviously scared about what that basic structure is. So I was just wondering if there's an objective standard to this. Do you think every constitution should have a basic structure as a counter-majoritarian difficulty, especially where you have the very real danger of majoritarianism actually defining that basic structure? So there. Thank you.
I will just say quickly, first of all, that Muhammad Ali Jinnah was a dynamo barrister in the Bombay High Court for decades, and ended up spending some time in London representing Indian appeals to the Privy Council. So he absolutely his role is important in all of this. The Felix Frankfurter Rao exchange is part of the book. So I highly recommend that you can read more about it in the book.
Yes, again, I think we do need to acknowledge the contributions of Muhammad Ali Jinnah. I'd also point out that when the Bhagat Singh case came up in 1931, and that's where the Privy Council did something quite terrible. It very easily upheld the execution of Bhagat Singh, Rajguru, and Sukhdev. But when the trial was going on in India, it was Muhammad Ali Jinnah who provided the most eloquent defense of the prisoners who were on hunger strike in Lahore jail. What the British Raj was doing was to enable the trial to go on even without the defendants being present. And the speech that Jinnah made in the Central Legislative Assembly castigating the colonial government, I think it should be read by everyone today. I think it is referred to in Niti Nayar's book, Changing Homelands, which is a study of the Punjab from 1907 to 1947. Now, in terms of basic structure, if you have an overall good constitution, I think it is important to have a basic structure doctrine. I think it has been valuable for India. And what I would say, thinking about the other side, as you invited us to do, Pakistan, of course, has had many constitutions, the 1956 Constitution, then the 1962 Constitution, the Basic Democracies Constitution introduced by a military dictator, the 1973 Constitution. In my view, the 1973 Constitution is actually a good one if it is actually honored and not breached. And if there were, particularly in terms of the federal aspects of the 1973 Constitution. So in fact, if there were a basic structure doctrine to protect the key elements of the 1973 Constitution, it would have been a good thing. But as we all know, there have been very strange amendments under military rule, that have come about subsequently, and it's been very hard to roll them back and so forth.
Are there any other questions?
Well, I guess I'd just say one thing about several of the observations, which is that there's a serious issue of a disjuncture between articulated doctrine and actual practice. And so the basic structure doctrine is sort of the most notable one in that, as was observed, it's only been invoked with respect to the judicial branch's self-defense. I should note that it might serve as a caution against trying to do some things that might run up against later adjudication, but still the actual practice is quite narrow. And that's true across a fairly wide range of what the court has done. So yes, it's articulated an activist doctrine across a fair number of areas, not everywhere, as the terrorism stuff indicates. But you can't overestimate the effectiveness of what they've actually done.
I will just say that I very much appreciated Professor Bose's perspective as a historian legislator, which is almost, well, I don't know anyone else, put it that way, who combines those two roles, and reminded us that today it's particularly important for the Indian Supreme Court to defend constitutionalism in an age of the Hindu right basically being in power. I want to just connect this to the place where the very last chapter ends up in the book, because it kind of surprised me. The last chapter kind of ends up saying that George Gadbois wishes that the Indian Supreme Court would, in a sense, defend individual rights a little bit less and give more space to government. And I thought, when I read that, I thought that he would probably come out a different way if he had been writing after the emergency, and perhaps if he had been writing today.
Well, I agree with Professor Sharafi on 2 points. One, of course, is what she said about the rule of law. And there is some good historical scholarship which has shown how the rule of law became despotism of law in certain phases in the 19th century. I'm thinking of Radhika Singha's book, which is, of course, a book that came out a long time ago. I agree that the Supreme Court has a role to play, but I also, in some ways, share the pessimism expressed by Vasujit in his comments that we probably should not have very high expectations of the potential counter-majoritarian role, and therefore, the battle for democracy, substantive democracy, and the protection of constitutionalism and constitutional rights have to be waged on many fronts at the same time.
Thank you all for your excellent comments, and thank you so much for coming today.